If you're watching this because you or someone you love is waiting on a US visa or a green card, listen carefully. Because January 2026 didn't just bring updates, it brought a pattern. One door tightened, another door quietly opened, and a few rules flipped so fast that many people still don't realize what changed. Today is February 4th, 2026, and what I'm about to explain can save you months of delay, thousands of dollars, and one massive mistake that gets people stuck in limbo. Stay with me for the full video, because near the end I'll share the simple 3-check system you can use in 2 minutes to know whether these changes help you, hurt you, or demand immediate action. Let's get one thing straight. US immigration doesn't change in one big headline. It changes in pieces: policy memos, visa bulletin movement, program expirations, temporary rules that become the new normal, and extra screening that doesn't sound scary until it hits your case. In January 2026, several of those pieces moved at once, and when people feel confused, that's when scams explode and bad advice spreads. So we're going to slow it down, make it simple, and focus only on what matters to real families, seniors, and retirees who just want clear answers. First, I want to talk about the Visa Bulletin because this is the heartbeat of many green card cases. Every month, the U.S. Department of State publishes the Visa Bulletin. This is where you see final action dates and dates for filing. In January 2026, the bulletin laid out where family-sponsored categories and employment-based categories stood, including common backlogs for countries like India, China, Mexico, and the Philippines. It also highlighted something most people skipped over. Certain categories have special rules, special limits, and even program deadlines that can instantly freeze progress if you miss them. Now here's where the U-turn feeling begins for a lot of viewers. In January, the bulletin openly warned about the scheduled expiration of a specific part of the employment-based fourth preference category. Certain religious workers, sometimes referred to as the SR portion. The bulletin stated that the category was extended only until January 30th, 2026, and that after midnight, January 29th, 2026, no SR visas could be issued overseas or finalized for adjustment of status cases unless Congress acted again. That kind of deadline creates chaos. Attorneys rush filings, families panic, and people who were almost there suddenly face a wall. Then February hits, and the situation gets clearer, but also harsher. The February 2026 Visa Bulletin lists certain religious workers as unavailable for all countries. That means for that month, that door is effectively shut under the bulletin's published availability unless there's new legislative action that reopens it. For viewers, that feels like a U-turn because one month you're tracking dates, the next month it's simply you. But at the exact same time, here comes the twist. Another change moves the other direction. DHS announced an interim final rule that eliminates the one-year foreign residency requirement for many R1 religious workers, who previously had to remain outside the U.S. before returning after hitting the 5-year maximum. The government's message is basically, the immigrant path in one slice of EB4 got more uncertain, but the non-immigrant continuity for religious communities got easier. That's why people call it a U-turn. It's not one clean move, it's a split move. Tighter in one place, looser in another, and the public only hears one headline. Now, if you're a senior or retiree watching and thinking, that's not my category, don't click away, because the lesson matters for everyone. The lesson is this. In 2026, you cannot rely on old assumptions. You have to track the exact program, the exact category, the exact month. People lose time because they're following immigration news like it's weather. It's not weather, it's rules. Next, let's talk about work-related visas, because even if you personally aren't applying, many families depend on a son, daughter, or sponsor whose job-based status supports the whole household. USCIS explains that DHS and the Department of Labor jointly announced a temporary final rule increasing the H-2B cap by up to 64,716 additional visas for fiscal year 2026. But there's a catch. These are not free extra visas for everyone. These supplemental visas come with conditions, like the employer needing to attest that without these workers, the business faces irreparable harm, and a large portion being limited to returning workers. That's another 2026 theme. The government is willing to open an extra lane, but only with tighter controls and paperwork. And this is where viewers get trapped by viral misinformation. Some channels say, America is opening visas, apply now. Others scream, everything is banned, nothing is possible. Both extremes get views. Both extremes mislead people. The reality is more frustrating, but more useful. Targeted expansions and targeted restrictions can happen in the same month, even in the same category family, depending on the legal authority and the political priority. Now I want to address something seniors and retirees care about most: predictability. If you're planning family reunification, or you're waiting for a child's case to move, you don't just need hope, you need a plan. The Visa Bulletin is part of that plan. January and February 2026 bulletins show continued management of demand through cutoff dates, and they also show how quickly availability can change when a program is time-limited or when statutory numbers hit pressure. That's why you must stop asking, is immigration open or closed? And start asking, which category, which month, which rule, and what is the next step if it changes? Let's make this as practical as possible. To avoid confusion and costly mistakes, it's important to follow a simple 3-check system, starting with the most basic but most misunderstood step. After watching this video, if you apply this system, you will already be more prepared than the majority of applicants. Many people panic when they hear about visa rule changes because they assume every update applies to everyone. That assumption is exactly what causes delays, rejections, and missed opportunities. The goal here is not to react emotionally to headlines, but to understand exactly where you fit in the system before taking any action. The first check is identifying whether your case falls under an immigrant visa path or a non-immigrant visa path. These are two completely different tracks, governed by different rules, timelines, and priorities. Changes announced for one category do not automatically apply to the other. In early 2026, we are already seeing situations where one pathway is temporarily paused, restricted, or delayed, while the other continues moving forward with adjustments designed to reduce disruption. If you do not clearly identify which lane you are in, you may assume your case is affected when it is not, or worse, miss an opportunity because you thought your path was closed. Understanding this distinction is the foundation of making smart decisions under the new 2026 visa landscape. The second critical check is whether your visa category is subject to monthly numerical limits and official cutoff dates. Many employment-based and family-based visa categories do not move freely. Instead, they advance or retrogress based on annual quotas set by U.S. immigration law. This is why the Visa Bulletin plays such a central role in your case. Every month, applicants must carefully review the bulletin to see whether their priority date is current, and just as importantly, which chart applies to them. USCIS regularly switches between the final action dates chart and the dates for filing chart for adjustment of status applications, and using the wrong one can lead to rejection or long delays. Relying only on social media updates or viral posts without checking the official bulletin is extremely risky. It's the immigration equivalent of making decisions without looking at the road ahead. The third check involves determining whether your visa category is connected to a special program or a time-limited legal authority. Some immigration pathways exist only because Congress temporarily authorizes them, increases visa numbers for a short period, or allows special supplemental caps. These programs can expire, be paused, or change suddenly, often without major public announcements or headline news coverage. If your case depends on one of these categories, deadlines are not optional and timing becomes everything. Missing a filing window or assuming an extension will be granted can result in the complete loss of eligibility. In these situations, emotions and assumptions don't matter. Only the written law, official notices, and filing deadlines do. Now, I want to talk about what you should do today, February 4th, 2026, if you're watching this and you're anxious. If you are waiting in a preference category, your job is to get organized before your date becomes current, not after. That means your civil documents, translations, police certificates if needed, and financial sponsor documents should not be last minute. The biggest delays are not always government delays. Sometimes it's applicant delays that become deadly when rules tighten. If your immigration plan depends on an employer-based route, it is no longer enough to simply ask whether you qualify. In 2026, the real question is how and when you qualify. Different visa programs now operate within specific allocation windows, start dates, and filing timelines that must be followed precisely. For example, supplemental visa programs such as H-2B increases are limited not only by eligibility requirements, but also by strict timing rules. Employers must submit applications during the correct window, use the correct forms, and complete exact attestations required by USCIS and the Department of Labor. A small mistake in timing, documentation, or filing sequence can result in a petition being rejected, even if the worker is otherwise fully eligible. This is why coordination between employers, attorneys, and workers has become more critical than ever. For families and organizations supporting religious workers or community-based workers, it's equally important to understand how different visa categories interact. Immigrant visa availability under the EB-4 category and non-immigrant status under the R1 program operate under separate legal frameworks. A change or pause in one category does not automatically cancel or invalidate the other. However, many people assume that a policy shift affecting EB-4 visas means R1 status is also impacted, which is not always the case. This misunderstanding has led to unnecessary panic and poor decision-making. The key U-turn most people miss is recognizing that continuity in non-immigrant status can still exist even when immigrant visa availability changes, and knowing this difference can prevent avoidable disruptions to work, ministry, or community services. Before I close, let me warn you about the most dangerous thing in 2026 immigration: confident, oversimplified advice. Anyone who tells you this update applies to everyone is either chasing views or doesn't understand the system. Your case is a category, a date, a program authority, and a process, not a headline. Here's what I'd like you to do right now if you want this content to perform even better for your specific audience. Immigration updates affect people very differently depending on the type of visa and the country they are applying from, and videos that speak directly to those details consistently get higher watch time and engagement. If you're open to it, comment or message me with just two things. First, the primary visa category your channel focuses on, such as family-based green cards, visit visas, student visas, or work visas. And second, the top 3 countries where most of your viewers are located. With that information, I can rewrite this script into a highly targeted country plus visa version that uses sharper suspense points, clearer relevance, and stronger retention cues, along with a closing call to action designed specifically to keep viewers watching longer and interacting more with your video.